Good afternoon, everyone. My name is Sean Timmons. I am the managing partner of Tully Rinckey PLLC's Houston, Texas office, and I handle military litigation around the world. I also handle USERRA employment disputes and other Title VII disputes around the state of Texas and across the country. I also have a nationwide, worldwide, global practice representing members of the armed forces pretty much everywhere they're stationed, and members of the armed forces are stationed throughout the world: South Korea, Japan, Europe, all over the continental United States, Alaska, Hawaii, you name it. What I wanted to do today was go through some court-martial war stories and go through some common theme and theories I noticed. I recently had a fully litigated court-martial with my colleague Ira Rushing out of our Mississippi office. Ira was a great associate to help me out. Michelle in our Puerto Rico office also helped out considerably, and so did the entire law firm and team. We're a group team approach here, so I want to thank everybody who's assisted me over the years in these different court-martial wins. But I've learned some commonalities with these court-martial full acquittals. Let me start off with the basic premise. More about me. I've been litigating now for 17 years, and I've been an attorney for a while. So anyway, that's enough about me. You can read more about me on my webpage, bio. Happy to read stories out there. You'll find all kinds of stories on the web, clients represented. And again, I represent individuals across a wide spectrum of the law. So I don't necessarily pick my clients. The clients pick me, and I give them full, thorough advocacy. So some of the stories are a little, eye-opening, to be kind about it. And that they're deliberately so, because people in difficult situations need a good attorney, and often those facts are what they are needed. Regardless, we're going to go into a presentation today to discuss some key elements of these war stories. And for today's webinar, common mistakes prosecutors make in court-martial trials. Some common themes I've noticed. I've litigated court-martials against every branch of service. The Army, the Navy, Marine Corps, all the three major branches. We've had court-martials even with the Coast Guard in our firm. I haven't personally been in front of a Coast Guard court-martial. They're very rare. But I've had plenty of Army court-martials, Air Force court-martials, Navy court-martials, Marine court-martials. Average, several a year for 9 years now in private practice. And prior to that, I was a JAG in the Army. So my court-martial experience is significant. And in private practice, it's significant because generally most cases statistically don't end up going to a fully litigated trial. And then to have a fully litigated trial result in a full acquittal, that is supposed to be statistically rare. It's not as rare as you would think in the military, and there's some reasons behind that. But for example, in the federal system and the federal court system, according to the Department of Justice and the recent statistics they publish, when the Department of Justice takes a criminal indictment to a federal trial with a jury, their conviction rate is 98%. That means a full acquittal is 2%. Very, very, very rare. The military statistics, full acquittals are higher than that, but they don't publish statistics, to my knowledge, on the actual full acquittal rate. So it's your best guess on what the overall full acquittal rate is. But I will tell you, General Risch, who was my staff judge advocate at Fort Hood back in 2009, admonished all the JAGs and told us all in a room, very heated, very passionately, very angrily, full acquittal is not acceptable. And under no circumstances should we prosecute a case that results in a full acquittal. A full acquittal is an embarrassment to the JAG Corps, and a full acquittal is a humiliation of the government, and a full acquittal shows the case never should have been prosecuted, or a grave mistake and error was made. And what we need to learn from that to avoid it from happening in the future. Because you have to think, the government has unlimited investigative resources. They have budget that is massive. They have investigators. They have subpoena power. They have wiretapping power. They have agents. They can knock your door in and gather your stuff. They can get warrants to seize your devices. They can extract all kinds of information. They can go, encourage witnesses to turn against you and cooperate. They can, the amount of power and effort and energy they can put behind a prosecution to prove the elements is quite literally unlimited based on primarily only their discretion. However, your resources are generally limited significantly. And if you're with trial defense services only, your resources may be gravely limited. If you have private counsel and you have a budget to hire your own attorney, your resources may be significant, but they may not match the endless resources of the government. So how do we end up with these full acquittals? Well, the Air Force often makes what I call mistakes of pride. They prosecute cases that are Article 15 turndowns, and the Article 15 maybe should have been a reprimand. Maybe it should have been an admonishment letter. Maybe it should have been a counting statement. Maybe it shouldn't have been an Article 15. But people turned it down because they felt there was some evidence of innocence, and the standard is beyond a reasonable doubt, and they prosecute it anyway. The Air Force has this blanket policy of, if you turn down Article 15, we consider it spit in the face, and we will ruin your life by taking you to a trial. Well, that's arrogance, and that's irrational, and it results in some full acquittals. And I've had that experience multiple times in the Air Force when my client turned down Article 15, thinking that they were innocent or they were getting hosed, and we called the Air Force's bluff, and we went to a trial, and ultimately they didn't have the cards they thought they had, and a full acquittal happened. The Army has a lot of problems with prosecuting cases that should have been handled via an alternate disposition, meaning a separation board or some other kind of action. Many times the cases have witness credibility issues, and they just didn't do their homework on determining whether the witness providing the adverse evidence against the soldier was credible or not. Same problem with the Navy and Marine Corps. Even deeper than that, though, I've noticed in my own personal experience, the government prosecutors just not experienced on voir dire and allow members of the panel who are very pro-defense somehow on the panel. And they should have used their preparatory challenge, and they should have used other methods to challenge individuals sitting on the panel, but they let some really pro-defense panel members slip on through, which is great for us. They didn't notice it. Their own neglect caused them to avoid throwing somebody off the panel who they should have identified to remove. But it worked out beautifully for us. So I don't want to give away today all the secret sauce, because obviously there's a lot of methods behind each case, and every case is different. One of the law professors I had very first year of law school provided me, look, any lawyer can win every case if you just change the law or change the facts. Well, we're not a casino. We can't rig it. And unfortunately, the law is usually what it is, and the facts usually are what they are. So our job is to work with the facts and the law as they exist, and not as if we wish they were. That makes, ultimately, it's inevitable you're going to lose cases as in private practice. It's not possible to win everything. It's not a casino where you can just, change this deck of cards and reshuffle it until you come out statistically ahead. It's not the way it works in litigation. However, there are certain things you can do to increase your chances. And I've noticed a pattern of embarrassing prosecutorial incompetence across all JAG branches, primarily due to the duress Congress has placed on members of the uniformed services to prosecute cases that lack merit. For example, General Wells was named the leader of the special prosecution team for the Army, the head of the new special judge advocate branch that was going to prosecute sex crimes. And he was removed from his position because in a prior role as an attorney, he was a defense attorney. And in that role as an advocate, he mentioned to his staff that, hey, we're fighting some cases that are frivolous. And because he was such a strong advocate as a defense attorney, he got removed as a prosecutor in charge of prosecutions. What does that demonstrate? That demonstrates the duress from the Senate and the Congress and the oversight on our armed forces still exists, and it's still causing them to move cases forward that ultimately lack evidentiary merit and ultimately result in, predictably, full acquittals. But you still have to go through the motions, because if you don't do a good job presenting your side of the story, the government will win by default. And the government ultimately does end up convicting people who truly should have been found innocent, but for lack of good representation, which is a scandal, a national scandal. There are currently countless numbers of innocent people sitting at Fort Leavenworth today who are in jail for behavior that in prior generations would have been seen as normal and routine. To me, that's personally a scandal. You know, a 20-year-old makes a mistake, spends the rest of their life as a registered sex offender. To me, that seems excessively harsh. That's the current state of the law. So again, this is all coming from a defense attorney's perspective. I will fully admit my bias. I would fully admit my hair is gray on the sides significantly, probably prematurely. Why? From stress of fighting battles against this, you know, David and Goliath type scenario over and over again, where you have this government monster, the Godzilla, stepping on people left and right, pretty arbitrarily, honestly. And how do you fight back? How do you hire King Kong to fight Godzilla to make it a fair fight? Well, let's walk through it step by step. Let's go down to war story number one, and that is the time. This is a prior case. This is a drug prosecution, and the Air Force, in their wisdom, decided to prosecute my client, even though they did not have a positive urinalysis. Generally, you would think if you're going to prosecute somebody for wrongful use of drugs, you'd want a test that showed there was wrongful drugs in their system. In this case, they had no such test. All they had was evidence from another case from a romantic lover that apparently showed consumption and use through photographic evidence that was available from a prior prosecution, an ancillary case. So what the Air Force did was use a bunch of hearsay and speculation, rumor, innuendo to charge our client for having a girlfriend who was a drug dealer. He denied knowing she was a drug dealer. He denied any knowledge that she was involved with drugs. But because she was prosecuted for dealing drugs, and the Air Force screwed up the prosecution, and ultimately charges were all dropped because they couldn't get any evidence in, they tried to get their, quote, revenge and the merits of their investigative work by then prosecuting her boyfriend, my client, for similar stuff, even though he had nothing to do with her side drug business that he had no knowledge of. Ultimately, predictably, we got a full acquittal. The government had nothing but conjecture, speculation, rumor, and what they thought were some photos of him, you know, smoking blunts and consuming THC, but we didn't have any actual meat behind it. And, you know, what you smoke, we don't know what it is. Could it be cigarettes? Could it be, you know, vaping, you know, grape juice? I have no idea. And neither did the panel. The panel had no idea what the government was trying to get at because they had no positive UA. They had no evidence from any credible witness of drug use or purchase or transmission or possession. They had no evidence of possession. They had no evidence of prior use. All they had was speculation and a bunch of 304 evidence that was kept out, confusing of the issues, needless presentation of cumulative evidence, lots of just complete, utter hearsay. And hearsay is information outside the court to prove truth of matter asserted. Well, unless you have an applicable exception to get the hearsay evidence in, it doesn't come in. And we were able to keep out almost the entire government's case based on hearsay objections. In fact, we should have won what's called 917 motion. And at that 917 motions argument, I presented to the judge, Your Honor, look, the government came here with a case of wrongful drug use and they presented no evidence of it. The case should be dismissed as a matter of law. And the judge painstakingly saved the government by saying, well, actually, the panel could hypothetically, maybe, somehow see, I have to give all deference to the government. The standard is to give all reasonable inferences to the government. I could see how they could think the picture might be evidence of drug use. Therefore, and combined with the witness testimony of hearing that he associated with the drug user, that, you know, this was classic guilt by association. Just because your romantic lover has committed a crime doesn't necessarily mean you've done anything wrong. You could be, he wasn't charged with conspiracy. He wasn't charged with facilitating her drug business. He wasn't charged with financial gain from her drug business. He wasn't charged with anything to do with what she was allegedly previously being prosecuted for having done. He was simply charged with wrongful use of drugs, which he never actually did, according to his version of events. We got a full acquittal based on the totality of the government's ineptitude in trying to prove a case basically through hearsay. And again, I consider this arrogance of the Air Force. They had a case where they thought they had all these people who were criminals, drug users, and ultimately they were able to convict nobody because they couldn't put it all together and they didn't do their homework properly. So it was an embarrassment to the Air Force, a great win for our client. But our client did have to go, year and a half of his life in limbo. Couldn't ETS, couldn't move on with his life, couldn't get his honorable discharge, was stuck in the military criminal justice system, pending resolution via trial, and ultimately did get a full acquittal and was exonerated and got his honorable discharge and moved on with his life. But the war story lessons learned here is, number one, the government will try to bring in all kinds of inadmissible evidence. So be ready to object. Have your military evidentiary foundations book ready. When the government tries to lay the foundations and they do it half-baked, absolutely call them out on it. Absolutely fight them every step of the way. And when they try to bring in hearsay evidence, object, keep it out. And the government has a half-baked response, well, then that's predictably what's going to happen. It's going to be kept out, and the panel will hear very little of what they intended to provide. Again, why these kinds of cases are better left for administrative separation boards. At an administrative separation board, the only rule of evidence is relevance. Relevance is a very low standard, and you can bring pretty much everything in. That's why they call administrative separation boards kind of like kangaroo courts. You can pretty much bring in everything as long as it's got some plausible relevance. It's totally acceptable to bring it in, which is unfortunate because these boards become circuses sometimes of stuff that is just complete horse manure. But it's permissible under the rules because any relevant evidence can be adjudicated in separation boards except for privileged communications and other very limited exceptions. 412 maybe. Some evidence is kept out, but very limited in separation boards. Mostly everything's fair game. And court martials, they have to follow the overall strict rules of evidence because the standard of proof is beyond a reasonable doubt. And the government here, in this case, just couldn't do it. So I could talk a lot more about this, but I'm breaking too much. I'll be getting far beyond what I need to talk about. So let's move on to the next one. All right, the next one is probably my favorite one. And this is another full acquittal. And again, this is a warning. If you have children around in attendance, you might want to mute their ears for a few minutes because these facts are quite graphic. The facts of the case are graphic. So describing the facts in the case and the full acquittal, I think it's necessary to give a full description of the story. So I have to put a disclaimer warning that the rating on the discussion is now up to an R. So I would not have children under 17 or 18 listening in for the next 5-10 minutes. I would ask that any minors tune out for the next 5-10 minutes, not to listen to this description and to only listen to it with parental consent. That being said, rape cases that are called sexual assault in the military, Article 120. And a lot of times these prosecutors forget a very key part of the analysis. Yes, sex without consent is a crime, but there's another analysis, and there's a doctrine called mistake of fact. And that mistake of fact doctrine at one time was actually written into the statute, meaning in the Manual for Court Martials, 1969, if you pull it from the Library of Congress, if you look at page 339 of the Manual for Court Martials that was written in 1969, that was applicable for 15 years. So for a decade and a half, this was the actual law as published for all rape cases from 1969 to about 1983, 84. It's basically said, and this is a direct quote from the language. They wrote, it is true that rape is the most detestable crime, but it also must be remembered that an accusation is easy to be made, hard to be proved, but harder to be defended by the party accused or innocent. That's actually written in the statute. And it goes on further to state, force and lack of consent are indispensable to the offense. Thus, if the female consents, is not rape. The lack of consent required, however, is more than just mere acquiescence. If a woman is in possession of her mental and physical faculties and fails to make her lack of consent reasonably manifest by taking such measures of resistance as called for, you may infer consent. That was the actual written law requiring, opposition, defiance. That's not the law today. The law today is you can be prosecuted when there's no evidence of an involvement whatsoever, meaning mistake of fact is still a defense, but it's not a statutory defense up front that the government has to overcome. It's now an affirmative defense you have to show with proof. So you have to demonstrate, the defense has the burden to notice the government of the affirmative defense of mistake of fact, and defense has the burden to establish there's evidentiary support to demonstrate an instruction to the panel on what I just read to you exists, meaning mistake of fact, meaning even though consent may not have existed, if you reasonably believe consent did in fact exist, then you can be exonerated and acquitted and not found guilty of rape. This is the part, the reason why this was put in the statute 30, 40 years ago was precisely to prevent what I consider the plethora of cases that are weak from an evidentiary point of view. The policy was, look, we really don't want to prosecute cases that nobody's going to really know what happened. We only want to prosecute cases where there's evidence of harm, injury, more than psychological injury, but injury, like physical injury or abuse or real predatory behavior, real horrible malicious conduct. We don't want to prosecute these drunken, stupid decisions that people regret later. That was the policy 40 years ago, 50 years ago. Well, policy changes have come along, and now we prosecute everything. And we prosecute stuff that has little merit whatsoever, because a lot of people go to the psychiatrist or the therapist and learn they're a victim and learn 2 years later, oh, what they experienced was victimization and trauma. And they didn't, in fact, consent. And therefore, they actually were victimized and they're a victim of a crime. Well, in my opinion, that's not true, because if you factor in the doctrine of mistake of fact, they were actually innocent. And the people who were the perpetrator was actually innocent, even though the perpetrator may have been a total scumbag. Did he commit a crime or she commit a crime? Probably not. And unfortunately, we prosecute cases now where, had the law been in effect as it was previously, it would not have been prosecuted. So if the Manual for Court Martial 1969, Article 120 was still in effect, I would argue 95% of the court martials in the military in the last 10 years would not have been prosecuted. That, even if the acquittal rate's 50-50, that means half the people are in jail today for crimes that would never have been prosecuted. But for the law stripping out this defense in the initial language. And it's on the burden on the defense attorney to present facts to show the mistake. That's a significant hurdle we have to overcome. We have to demonstrate, hey, the mistake of fact was reasonable, the mistake of fact existed, the mistake of fact is proved by the facts of the situation, not the government having a burden to overcome it. The defense has to prove it. Well, in this case, the defense was able to establish it relatively easily, but still we had to go through the motions and demonstrate it, because here we had a sexual encounter on a Friday, Saturday, and a Sunday over a 3-day period. And on Monday, my client, being the upstanding citizen that he was, told the victim, oh, you want to see me again? Thanks. Or words to that effect, but my girlfriend's not going to like that. Well, upon learning that he had a romantic affiliation with somebody else on Monday after having sex all weekend, everything that happened now had become criminal, according to the victim. But that's not the law. The victim then goes to OSI with the story of, this is the really graphic part, of lack of consent to anal penetration. Yes, I consented to vaginal penetration on Friday, on Saturday, and Sunday. But on Friday, the very first encounter, it was anal intercourse, and I did not consent to that. And okay, but you went back on Saturday and had vaginal, and again on Sunday and had vaginal, and on Monday you found out he had a girlfriend, and that's why it was no longer consensual from the beginning. You see the problem logically with the story from the beginning. Well, here it was just the way we got the win on the case was just flushing out the story from the quote victim on cross-examination. And the victim fully admitted exactly what I just described. Yeah, I totally consented on Saturday and Sunday, but on Friday I did not consent to the anal, and that was rape. Well, that was the story that was provided. But our client, again, go back to the take measures to demonstrate lack of consent. He reasonably believed it was consensual, based on the additional sexual activity. And that was the argument we were able to make to the military judge to demonstrate the mind of the accused. The accused reasonably believed the consent existed based on the later subsequent sexual activity. Even if it wasn't, he reasonably believed it was. Therefore, full acquittal. And that's the story of full acquittals on these sex cases, time and time and time again. Two people engage in sexual behavior, they later regret, one of them at least regrets it, and they file a complaint, and it wasn't a crime until the relationship broke apart. Great example is another case that's known pretty well, a colleague of mine, the 179th OBC, good captain friend of mine from JAG training. He had a similar situation. He had a S&M relationship with a girlfriend, another lawyer, and everything was going great until they broke up, and then all of a sudden everything that happened was no longer consensual. Well, he had a trial on the merits and was fully acquitted, and it was all a mistake of fact again because the defense was able to show all kinds of evidence of consensual behavior. So if the defense can show consenting activity after the alleged violation, you're going to demonstrate doubt to the validity of the accusation. And that doubt is what you need to demonstrate mistake of fact and get a full acquittal. Again, I feel sorry for people who are victimized by being violated sexually. It's not a comfortable position to be in. This is from a technical legal perspective. So I do not want to diminish people who have suffered from being victimized by lewd behavior. Lewd behavior is unacceptable. I do not condone it by any means. I've had a lot of people who I've represented who I personally am like kind of feel icky about having to help, but everybody's entitled to a vigorous defense under the law. No different than a doctor at the emergency room who's treating a gunshot wound to the knee. If the person has all kinds of gang tattoos all over their leg, it doesn't matter. You still got to treat their knee. It doesn't matter if they may have been shot in the knee from a drug robbery gone bad. Your job as the doctor who's fixing the knee is to fix the knee, not to create moral judgments about how their knee got to the point where it needs surgical intervention. So I'm in the same situation when it comes to defending people accused of sex crimes. My job is to give them a vigorous defense. My job is to give them full, thorough advocacy. Yes, their sexual proclivities may be morally repugnant to many and maybe unacceptable behavior to large numbers of the community, but it doesn't make it a crime. And being promiscuous is not a crime. Having sexual partners is not that consent, that are adults that are willing, is not a crime. It may be morally suspect, especially if you're married and you're engaged in activity, or if you have committed relationships and you're violating the trust of the relationship. Certainly may be morally objectionable, but is the behavior criminal? Possibly no. And if you can show mistake of fact, you can get a full acquittal. And in this case, that's exactly what happened. And the key fact was the quote victim wasn't actually victimized. What the truth was, she was emotionally traumatized because she invested time in my client and he was not entirely forthright about his relationship status. Happens all the time. I call this the Tinder / Bumble / Match date gone bad. And unfortunately, that happens quite a bit. I've had Air Force Academy cadets almost lose their status because they met somebody on Tinder and it went south, and then all of a sudden they call the command, and it's a big circus. A lot of spiteful people like to call military commanders about sexual situations that are really private in nature and are nobody's business, and it's really unfortunate, and it's really quite sad. Again, there's Dr. Brian Sweeney, an expert witness of mine, who's testified and helped me out on half a dozen court martials over the last 10 years, has told me words to the effect of he does a lot of treatment and he does a lot of counseling in his role as a forensic psychiatrist and a therapist. And the culture today, everybody wants to be a victim. And unfortunately, many times you're not a victim of a crime, you're a victim of your own poor mistake. And we make mistakes. We're all human beings. We all make bad decisions. But a bad decision does not mean you've been necessarily victimized by a crime. And I hate to, again, this is from a defense attorney's perspective. So if it rubs people the wrong way, I fully apologize up front, and direct all the arrows to me, because I made this disclaimer initially. These war stories and this perspective is my opinions and my analysis only. None of this is attributable to anybody else, Tully Rinckey PLLC, and none of this is attributable to any other attorney. It's simply my independent observations as an attorney and advocate for clients facing some pretty gruesome charges. Let's move on to trial number 3, maybe full acquittal. This is another example bleeding into the theme and theory of what I was just talking about. This is another case where at a relationship breakdown, girlfriend, boyfriend, girlfriend gets upset, boyfriend may have been seeing somebody else, wasn't happy about that, and the relationship breaks apart, and girlfriend goes to the police in Texas. Police listen to the story and, lack of better description, basically laugh her out of the building. And that's written in the notes of the investigation from NCIS. They write that the quote victim describes local civilian police literally laughing as they left the building. Why? Why were they laughing as they left the building? Because the story is a relationship breakdown. It's not a crime. However, armed with the knowledge that the police didn't believe the story, what does NCIS do? They do a pretextual phone call. And they get my client to admit to the entire sequence of events from the version of the quote victim. And my client, being the gentleman that he thought he was, admits to it. Everything. Yes, I'm really sorry. I'm going to analogize this to the arson elements, but you'll get, if you follow what I'm saying, you'll understand what I'm trying to get across. Yes, I'm really sorry. I burned your home down deliberately with the intent to destroy it permanently, knowing it's your dwelling, not mine, with the intent to commit a felony deliberately with malice aforethought. That would, if you had said that, if you were accused of burning down your neighbor's house and your neighbor called you and demanded an apology and you said all that, you would be guilty of the elements of arson, because arson is the malicious burning of the dwelling of another with the intent to destroy it permanently. If you burn your own property down, it might be an environmental violation, it might be EPA or a regulatory issue, but it's not necessarily arson, because arson requires the burning of the dwelling of another. The client, in his apology, admitted to everything. Yeah, I'm really sorry I did all these things while you were asleep, and please forgive me. Well, armed with that evidence, we were in deep crap, because if that came in and that was played, the panel very well may have convicted, because, again, check the box of the elements. Yes, I'm really sorry I stole your car and drove it to Mexico and left it there. And I'm not going to pay you any money for it either, but thanks, have a good day. That's kind of what he did. Not a good scene to be in. So the moral of the story there, from the war story from that, is when you're hit with a phone call demanding an apology, just hang up. Don't say anything. Because if you apologize and you start saying, I'm really sorry, yeah, I did all these things to you, I'm a terrible person, they're checking off the elements. The OSI, CID, NCIS agents right there. Yep, make sure he says this. Make sure he says that. Make sure he says this. Make sure he says that. Make sure he does this. I actually watched a really good movie recently on the way back from a flight. It's called Hitman, and it shows a pretextual, New Orleans police going out and putting ads for hitmen and getting the people there to describe what they want done. And as soon as they say certain keywords, now they're guilty of, soliciting murder. Similar thing NCIS does with these pretextual phone calls on rape cases. They have the quote victim call the perpetrator and demand an apology and demand a description of what they're apologizing for. And they're basically then admitting to have committed the crime. Well, thankfully, the government here had the B team for the prosecution, and we were able to exclude the confession entirely. That audio recording was never played to the jury. The judge heard it, 4 or 5 times. The panel never heard it once. And I'm not going to say any more on that, because I don't want to give away all the secret sauce of how we kept it out. But we kept out some key evidence the government had and they thought was a slam dunk, proved our client was guilty. And admittedly, if the judge had overruled our objections and it allowed it to be played, our client would probably still be in jail today. But for the last 5 years, he's been a civilian. He's been a free man, and he's gotten to restart his life. Why? Because that confession, that apology, that admission against interest that he made was all kept out of evidence. We won on that. And then what we were left with was her version of events. And we were able to demonstrate his version of events showed a mistake of fact. Additionally, the government really did have the B team here. In their opening statement, they referenced what the judge said was inadmissible. They referenced the confession. They referenced all kinds of stuff that was determined to be by the judge inadmissible evidence, not coming in. The judge ordered their entire opening statement strictly from the record and to be vacated. And that's basically what happened. And it was vacated and ended. And therefore, the government looked like a bunch of fools. And as the week progressed, they just kept fumbling the ball on witness presentation and cross-examination. And cross-examination was very effective in demonstrating a very passionate advocacy. In addition to that, the government was asleep at the wheel on voir dire. There was at least 3 old, and I apologize for the stereotypes, but if you're facing criminal charges in the military, you want on your panel old females. Old females are the best possible panel member, best possible juror. Why? Because if they've been in the military for a couple of decades, they're likely to be jaded, they're likely to be cynical, they're likely to be rough around the edges. And if they're jaded, rough, and tough and hardened, they're not going to take kindly to quote unquote mushy victims. In fact, they're going to be hostile to victims. In fact, they're going to be super extra hostile. And in fact, they're not going to believe anything, even if it's legitimate, because they're going to have a lot of actual disgust toward these softer individuals. That's been my personal observation and experience. And it was demonstrated here in this case. On this panel, we had 3 senior female officers, and each of them gave the dirtiest looks imaginable to the quote victim during testimony. It was almost, I had to hold back my laughter looking at it, because it was like hard to believe the government allowed them all to stay on the panel. They didn't strike any of them. All 3 of them got through, and that was them sleep at the switch. I guess they thought that it was good to have them on there, but the best person from the prosecution's point of view is a new father to a young girl. If you have a new father to a young girl, he's going to be extra paternalistic, extra protective, and extra sensitive to the quote victim, and more likely to convict. And you have an old crusty female who's experienced with a couple decades of military service. They're going to generally, and this is all general speaking, so there's always exceptions to all of this. They're generally going to be hostile to victims and be favorable to the defense. And that's exactly what happened here. Those 3 members were senior, and I'm pretty sure they deliberated and just did not believe the story whatsoever. And we got a full acquittal out of it. And that was great. Again, the government was asleep at the wheel on voir dire, which worked out beautifully for us. The government was asleep in evidence class and didn't get the confession in. We kept it out, and we were able to show a mistake of fact with the evidence they did have. End result, full acquittal. Next case, let's go down to story number 4. This one is probably the biggest victory I've had in a while. Why? Because truthfully, to be fully blunt, the client, if the government knew what they were doing, he should have been convicted of something. But again, it goes to the moral of the story. When you overcharge, you risk humiliating yourself to the extent you're going to lose all credibility. So if you, for example, if you're overselling a product and you're trying to sell it for far more money than it's worth, people might just walk away and be like, yeah, I don't even want to negotiate, because they're asking, the money they're asking for is unreasonable. Well, here the government put down the whole kitchen sink of charges when all they had to do was convict my client on the 3 or 4 things they actually had proof of, and he would be in jail today. But instead, they charged everything imaginable, and ultimately, we were able to poke holes in all the stuff that lacked evidence. And by poking holes in the charges that lacked evidentiary foundation and evidentiary support, the government lost credibility with the panel. And by losing credibility with the panel, the panel said, you know what, throw the whole thing out. And we got a full acquittal. We kept lots of evidence out that they tried to admit through the best evidence rule, through the government's failure to lay evidentiary foundations under authentication under Rule 901, the 803 series of hearsay, and they did not check the witnesses at all. The witnesses were proper to tell story A and came in and told story B. And we ran with it and had a great time, basically letting the witnesses undercut the government's own theories of the case. The government didn't examine their witnesses thoroughly at all. They just kind of rushed this to trial and thought the witnesses would say certain things, and the witnesses got on the stand and said something else. So, moral of the story there is, before you put somebody on the stand, actually have an idea what they're going to say. Don't just throw them up there assuming you know what they're going to say. You have to prepare your witnesses, and you have to diligently prepare your witnesses thoroughly to make sure what they're going to testify to matches up with your theme and theory of the case. Didn't happen here. We got a full acquittal. It was a great, wonderful victory. It was an amazing outcome. Kudos to my colleague Ira Rushing and everyone else who helped, Michelle Salerno and everyone else who helped out on this case. It was a great, great victory. And my client was fully exonerated after being in limbo for a couple of years there and faced lifetime sex offender registration. 3 out of these 4 full acquittals I talked about today, and in many other full acquittals, my clients have faced lifetime sex offender registration. And if you're facing the consequences of being relegated to jail for a very long period of time, and then when released from jail, the only job you're going to be able to get is the Home Depot parking lot doing hard labor, you really need to fight back aggressively because your life is pretty much ruined. I've talked to several people who've hired me for their appeal after they were convicted and served their time. And their job prospects are making sandwiches at Subway, flipping burgers at McDonald's, laying bricks at a construction site, maybe doing carpentry work, or running their own hot dog business within certain limitations because they can't be around schools. Your life is pretty dismal. And you can't travel internationally if you're a sex offender either. Most countries won't let you in. And you might not be you might not even be able to get a passport to leave. It's the restrictions on your life are significant and tremendous. So it's worth any price to avoid. And that's when you break glass in case of emergency, hire attorneys, know what they're doing, come in and fight back, and at a minimum, try to avoid the conviction that will result in lifetime sex offender registration. Because ultimately, all it takes to be a lifetime sex offender, registered sex offender is some pretty innocent stuff, some very, very basic misunderstandings. It doesn't take a lot to be a lifetime sex offender registered convicted felon. And that's personally, to me, in my own opinion, a scandal. But it's a scandal in reaction to the fact that for a long time we didn't treat victims properly. So what we did in the law was overreact. And what has the military done? They've overreacted. The military hasn't gotten it right ever. You know, decades ago they didn't take victims seriously. Now they prosecute stuff that has no merit. They've gone from one extreme to the complete opposite extreme. Obviously, victims deserve compassion and deserve justice, but you don't really have in the military, and I've never had this case, the ATM mugger scenario. You know, everybody is afraid of these vicious crimes you do hear about in the news media every now and then, where somebody's in the country unlawfully and they tie somebody up and they do some horrible criminal violations to them and leave them for dead. And those crimes, thankfully, knock on wood, don't happen in the military. In the military, the sex crimes that generally happen are a date that goes bad, people get drunk, make some decisions that are poor, and then wake up regretting it. And then 6 months later, they get a complaint about the fact that this relationship broke apart and now that they're a sex criminal. That's been the bread and butter of what I've seen. I haven't seen very many of the ATM mugger type random person off the street criminal stuff that everybody's afraid of. Legitimately so. I mean, you obviously be on guard for random zombies out there who are going to attack you and commit horrible crimes against you, and be protective of yourself. I'm not diminishing that possibility by any extent. I'm just saying in the military criminal justice system, I don't see those cases. My civilian colleagues may, and again, that's a different story. But in the military criminal system, we just don't see those cases. We see a lot of messy stories, a lot of bad dates, a lot of relationships that sour that really shouldn't have soured, a lot of I would say pornography influenced bad decisions, and it's unfortunate. And I can talk on a whole another day about that, but that's for a different webinar, different discussion. This was primarily to discuss some war stories of how we've obtained full acquittals against the odds. Again, remember, General Risch made it very clear, full acquittals should never happen. And if they do, that means the prosecutor did something wrong. And I fully agree with that. Full acquittals should not be happening, because for a full acquittal to happen, that means the government dropped the ball somewhere. The government has all the resources necessary to put you away for life if you're truly guilty. And if they don't, either they prosecuted something that you were truly innocent of, or they made a terrible mistake. In each one of these cases, it's a mixture of both. I don't really know if my clients are fully innocent or not. And my job is not to find out. My job is to give them thorough advocacy, 110%. We don't have Perry Mason style, oh, the real killer is Mr. X behind the bushes. That's not what happens in the real world. In the real world is everything's kind of gray and messy, and our job is to tell the story from our client's perspective to the best extent possible, as vigorously and thoroughly imaginable. And I'm sure I have a lot of people out there who absolutely hate me for doing so. And I welcome it, because it makes me stronger, it makes our team better, and we keep fighting a good fight, base to base, case to place, over and over again around the world. And if you or your loved one face the wrath of the military criminal system, you're going to want that, Godzilla in your corner, and that's our team. So in summary, it's been a pleasure to speak to you today. It's vitally important. If anyone you know or love is charged with a crime, to get good counsel immediately. I would be hesitant to rely on trial defense services, not because they're not good attorneys or don't care, but because they're inexperienced. I've been doing this now for a couple of decades. Did I know what I was doing when I started? Somewhat, but I'm a lot better at it today than I was then. And the longer you do it as a lawyer, the better you get at it, the more stuff you learn, the better you are. And you want an experienced litigator who has energy. You also don't want somebody who's about to retire and doesn't really care anymore either. You want somebody in the fight who's going to fight for you every step of the way with energy, endurance, stamina, fortitude, and that's personally our team. But there's lots of good options, and I would encourage everyone to make sure to have get the best outcome possible, to have the attorney who you think is going to fight for you the strongest. And ultimately, never take what the government says at face value. Always challenge their theme and theory at every single turn. Stay on offense. The way you win these cases is by holding the government to their burden. Making them need to jump through the hoops to get the evidence in they want to present. Stay on offense. Don't let stuff come in that you can object to, that you can keep out. And always throw monkey wrenches at them. Our job is to derail their train so you can have a second chance at life. All right. I'm going to go to some questions now. And people ask some pre questions. I'm going to answer those one by one. One question I've got is about fixing a service record. You can fix your service record by filing an application for correction with the Military Records Service Branch through a DD 149, or by retaining private counsel to fill out an application for correction to the military boards. There's a Army Regulation 15-185 that walks through the Army Review Board agency. There's Navy Review Board, Marine Corps, and Air Force Review Boards, Coast Guard Review Boards. Every branch has a review board that looks at military records and can make corrections to it if you petition for it. The burden's on you, though. The burden should be on the military to show it's correct, but unfortunately, Congress put the burden on the individual applicant. That's why you may need qualified, capable counsel if you need to fix your record. Happy to set up an appointment, talk to you offline. That's really case by case, situation by situation. One question: why does the military deliberately ignore prosecutors' misconduct and ineffective assistance of defense counsel? Great question. Military prosecutors are able to get away with unethical behavior because they're immune. There's no other description for it. They're immune because no state bar is going to second guess a military general. And all the prosecutors have to hide behind is, well, state Nebraska or Montana or New Hampshire or Maine, I was just following my military orders, and General X told me to prosecute, so I followed my orders. I had to do what I had to do within the military system. ethically, if the case lacks merit, they should say, I'm not going to do this. And there's a great example of that. Mr. Hexelon, who was, I think, Colonel Hexelon at the time, in the General Sinclair case, very well known, Army Times, did exactly that. So, you know what? I'm not prosecuting this. There's no merit to this. And he was, of course, railroaded out of the JAG Corps, to my knowledge, or had to retire or whatever. But he didn't get to keep his role. And same with General Wells. So that's going to happen. If you're a military prosecutor and you try to say, hey, time out, we can't do this, your career is pretty much over. So to avoid that, many of them just go along with it. And that's been the policy and process for decades. And is that ever going to change? I don't know. I doubt it. Do they ignore ineffective defense counsel? Yes, to some extent. The appellate court stresses sometimes by overturning convictions if the defense counsel's deficiency was extreme. But to be extreme deficiency, to violate your constitutional rights, has to rise to a level very, very, very high. So being just mediocre is probably sufficient. And if you have a mediocre only attorney, you might as well pack your bags for jail. That's why settling on a mediocre defense counsel assigned to you is really, really catastrophic. You wouldn't want a mediocre heart surgeon to work on your heart. You shouldn't accept a mediocre attorney to defend you when your entire life is in jeopardy. If your heart needs medical intervention, you want to pay for the best medical care possible, even if it bankrupts you, because having a heart is needed for the rest of your life. And I would say the same thing's true for having a defense attorney. Challenging the government's use of limited use policy evidence. Yes, the government violates the rules all the time. Again, you need to have capable, qualified counsel that's knowledgeable to know they actually are violating the rules, and we should stand up and fight back. And there's lots of examples of the government, either through neglect or ineptitude or whatever, violating rules. So I would certainly challenge that every step of the way. Next question. Wrongful titling of service members by corrupt SJAs. Yes, titling. There's another webinar I think we've done on titling, or we're doing one on titling. We've done lots of literature on titling. Titling is a national scandal. It's a scandal because, let me walk through it for a couple minutes real quick. Titling is a JAG prosecutor signing off on an investigator's determination that, or CID's determination that you have committed a crime. And they put it in the system that you committed sexual assault. Even if you were never actually prosecuted for the crime, if you were titled for it, it'll show up on a background check that says, for example, I had a client who applied to work for the police department in Houston, and he filled his application out, and they told him, sorry, you're denied because you're a burglar. And he's like, what? I'm not a burglar. That's insane. Well, it says here on your background check, you committed larceny and burglary. And was he ever prosecuted for that? No. He was given a letter of reprimand for entering his buddy's barracks room without consent and taking his iPad back, or borrowing his iPad and giving it back the next day, or something really stupid like that. But anyway, CID titled him with larceny and theft and unlawful entry and all kinds of other criminal stuff that had nothing to do with the actual facts. And it's permanently for 40 years in his national criminal data bank that he's a burglar, that he's a larcenist, that he's, does all these criminal things. So his explanation, eventually he was able to get a job in law enforcement, but he had to get it outside of a county nobody wants to work in, because they were able to accept his explanation. And it's a scandal, because reputable police departments were like, sorry, we can't have you on the team because the military is telling us you're a burglar, and we can't have that risk. That's absolutely reprehensible, but that's the titling process. You can petition to have titling removed, but the burden's on you to demonstrate your innocence. Really, really backwards. It's a big scandal. I would encourage everyone to demand Congress change the rules on titling and not allow it to be so permissive, because the way it's done is excessive, and it ruins a lot of people's background checks and lives over stuff that they never actually were prosecuted for, but they're titled, and the titling says they've committed this offense. And people reading military records don't recognize that it just means they were accused. It doesn't mean they were actually prosecuted for it. The way it reads to the data bank is they were convicted of it, and they were guilty. So big, huge scandal, and it needs to be addressed. Congress has made some limited, half-baked efforts to fix it, but it needs a lot more reform. And if you have a titling issue, you can hire counsel to petition the board to have it removed. But the odds are against you. It's an uphill battle. It's a real struggle. So titling is a whole other seminar, whole other presentation. But I do want to address that concern, because if you're facing a court martial, I guarantee you're titled, and that titling is not going to go away. But your freedom will come back. And if you're found innocent and they ask you about what happened with the titling, you just tell them, look, I had a trial on the merits and I was fully acquitted. So I'm totally innocent. Yeah, the accusation is there and you're seeing I was accused. That's all it was an accusation. I'm actually innocent. And a jury or panel or judge found me innocent after listening to all the evidence. So with that, if anybody has any questions or particular issues they want to address, feel free to reach out, set up an appointment, speak with us. We're happy to talk to you individually, one-on-one, with attorney-client privilege communications. Thank you for your time today, and that concludes the presentation.